All rise, please. Court's back in session.
Please be seated. Okay. Counsel?
Paul Gillespie for the state. Judges, this is case number 20 CF 2327, Janice Porter. Judge, we're here for sentencing. Ms. Porter has previously entered a plea with a stipulation to the lesser included count under organized fraud, the lesser included of grand theft, 20 to 100K, which is F2, level 6. She's also pled to count 5, level 1, first degree felony, level 7. Part of the plea was that we would agree to dismiss other charges. She's to be adjudicated guilty on this, set for a sentencing hearing, the lowest permissive sentence of 34.5 months. There is a cap of 8 years set by the state, stipulated to my understanding with the court. She's allowed to argue grounds to departure. So we're here today for sentencing hearing to address that. The state does not believe there's a grounds to depart. The state's going to be seeking 8 years of incarceration, and that's the state's position.
Any opening remarks, counsel?
Yes, Judge. I would inquire whether or not the court has been in receipt of the PSI.
The court is in receipt of the PSI, as well as your motion, I think, came in the last day or so on the downward departure.
Yes, Judge. And I guess the first thing we need to address is, in regard to the PSI, we do have some specific objections regarding that. And we're moving to strike the recommendation from the PSI as well. And I think those issues, need to be addressed so that the court can take into account the actual facts of the case and the actual disposition of everything that we've done so far in the case, so that we're on this, everybody's on the same page as far as what we're dealing with here.
I did note that there were objections that were made to the PSI, so.
Okay. If I could lay out
So
those
hold on,
objections,
hold
I'd
on.
like to do that.
Do you disagree that we need to address that at the front end, or arguments? I mean, I'm not sure exactly how to address objections to the PSI.
My understanding, the recommendations based on the probation officer's evaluation of what she's viewed and looked at it, I don't think the recommendation should be struck. That's their recommendation for the court to look at. As far as factual disputes, there are, as far as I know, I'm looking at his motion on that, the dealing with the foreclosure, my understanding that predated, it was in 2013. I think that may be accurate. I think that the best way to do this is probably just have the testimony taken of the witnesses that can clarify some of those issues potentially.
I'd like to put my objections on the record before we take testimony.
Okay. Hold on just a second. Okay.
Thank you, Your Honor. And Judge, let me preface my remarks by saying this. Please don't let my challenges to the PSI and the objections therein diminish my client's level of contrition in any way, or because just because we're challenging some of these things, it's not saying that she's not guilty of what she pled to. It's that but we have issues regarding the way that the PSI was characterized. On page 1, we object to the court data section in there. My client entered a plea to 2 counts of an information that, and that the fact that she was charged by information with other counts that she did not plead to should not be taken into account by this court in any way, shape, or form. Those may have been unprovable crimes. They may have been dismissed by the state. Either way, the court's consideration of those, or probation's consideration of those when fashioning a recommendation, should be stricken. Those should not be taken into account.
You want to deal with them one at a time, let the state
I'm not
respond, or you
finished.
want to do,
I'm not finished.
well, I understand that, but you want to take them one at a time?
That'd be fine, Judge.
Okay, we can go ahead.
Judge, the state, it should be noted that the state filed, when we were setting this case we were going to set this case for trial, the state filed a 7-count information in June, in which they added additional charges. And then about 3 weeks later is when we entered this agreement in which she pled to 2 counts of grand theft, which was substantially less than what she was charged with. We would just submit to the court that the only charges that she's before the court for sentencing on are those 2 counts, and that she scores minimum guidelines of 34.5 months on those counts. So that's the basic issue and that's listed in number 1 of page 2 of my memorandum for departure. Anything beyond that, we would submit as speculation that that if we went to trial, she could have been convicted of more counts. That's not for the court's review, nor should it be considered by probation when fashioning a recommendation.
Judge, my understanding, that's just court data. That's where we are. I think you're well aware already of what the charging information was and how we proceeded to where we are today. She's before the court today on 2 counts of grand theft, and that's all my understanding, intend to sentence her on. I don't see any issues with having it in the PSI. I have no objection to not having it in there for those reasons, but I don't see any issues with this. This is court data.
Are you objecting to it being removed and just being reflected with the 2 counts that are pled to?
That's fine.
Okay. Very good.
Judge, and the second issue is that in the PSI as well, there were some things that were taken from police reports and from letters and I understand that's how probation gets their information. Defense reserved the right to submit our recommendations and our information for ourselves to present that in sentencing. On number 2, there's citing to an initial report that the allegation is that the amount of money that was dispersed to the defendant were in excess of $700,000. The parties have since stipulated that the amount of restitution attributed to Ms. Porter is $307,000, and that we believe is prejudicial to my client in the sense that the allegation is that she was guilty of far more than what she was charged with or what she pled to, and that's prejudicial to us in a number of ways. Anything else beyond the stipulated restitution amount would be pure speculation, and the court should not consider what the state could have charged her with, what she may have been convicted with by a jury at a later date if we had a trial. So we would ask the court to disregard that part of the PSI and the facts therein. The facts of this case, and the reason I'm bringing this up again is this case it's a 2020 case. It's not a new case by any stretch. Criminal liability may have been established early on, but restitution took us a long time to figure out. And so that's what took all the time to get to the point where we're here finally in 2022. So that was a major issue of contention. But the fact that we reached a stipulation as to the amount of restitution is important for the court to understand, and it's also important that we've reached an agreement as to the charges. And like I said, speculation would be inappropriate. I know that this is something the court already knows, but I think it's important to put it on the record. Thank you.
Judge, this issue came up on the day of the plea. I don't know if you recall, we approached at the bench. On page 4, it says factual basis for the plea. The arrest report is circled. That's the basis for it. That's the reasoning that came out. I will note we had a lengthy discussion on that day, and in the plea it says the total restitution amount is of $307,000. I'm sorry, 307,000 amount of dollars there. The loss amount is also that same amount. What we didn't want to get into is a nitpicking issue at this point of what that figure was. That's what it is, but I do believe that we can talk about what was discovered. My accountant's going to talk about what was discovered through this process. The state does agree that the amount in question, the amount that she's legally liable for, criminally liable for in this situation, is $307,000. So that's where we are with that. I think that references...
You said something different. There's one thing, I think there's a nuanced difference between what she has responsibility for by way of restitution. We're all in agreement on that. But you said something else, that there was agreement as to the loss of that. Is that correct?
What I placed in
Where's
there,
that language?
the language is, and the amount of loss stipulated to at $307,000. So that's where we are with that. I didn't want to argue that issue and nitpick too much with this.
I understand you didn't want to nitpick, but you agreed to it.
Correct, that's correct. That's the amount that the state criminally she is liable for as far as the loss amount.
You're putting words in there that aren't in there. There's a loss
We can
amount,
understand that.
there's a loss amount, that's what it is, and there's restitution, it's the same amount.
Understood.
Okay, that's what's in there.
That's
What's
correct.
in there. I understand the nuance you're saying. If that language hadn't been in there, I actually might have disagreed on the restitution. Because if you say you can have something that have a difference between a loss and what's agreed to as to restitution. That's why I asked you about that. If you agreed that this is the loss amount, then we go with that's the loss amount. Anything else?
Number 3 on page 205 of the memorandum, and that's under the recommended disposition section of the PSI on page 7, referencing that portion. The officer indicated, and again, this is gleaning information from outside sources, that the charges were used to support a luxury lifestyle. There's no record of any money embezzled to support her family or housing. That we do have forensic reports and audits that do indicate that there was money that was utilized for family and housing, both. Not only housing and family, but mortgage payments and telephone payments, insurance, things of those matters. I don't know if we're disputing that at this point, but in fact, those items were in there and utilized that way. The officer criticizes the defendant for not using funds to save her home. We think that's an improper characterization or an improper speculative statement in there, which is prejudicial to our client. It's not necessarily fair to her. The fact of the matter is that there's a court case, 2012 CA 172, in regard to the foreclosure of my client's home that's referenced in the PSI. There's court pleadings which we could ask the court to take judicial notice of if they're in dispute. But that the foreclosure was entered in May 16th of 2013. The allegations are that it wasn't until after that time period is really when the allegation of my client misappropriating funds occurred. So there's no basis to suspect that my client could have used funds to save her home, and that would have been more, maybe a better way to spend stolen funds or something like that. That's not proper, and it's not possible. It wasn't even possible. So to berate her in that regard in order to try to maybe look at it as an aggravating factor in some way is not proper, nor is it appropriate, nor is it true. So if the state, I don't know if the state's disputing that, but if they are, we'd ask the court to take judicial notice of the case in which the foreclosure occurred.
Judge, I would argue that it was used for a luxurious lifestyle. There are some records, and I've mentioned in defense, there are occasional phone bills being paid, gas bills being paid, but the vast majority of this $307,000 was spent on luxury lifestyles, eating at restaurants, going to movies, doing those sorts of things. I would say, yes, that's correct. It's a luxury lifestyle, and that's not a mischaracterization of it. So I'd ask that it remain in, and I think the evidence would show that, too.
Well, the characterization, that's just one of, there were three things that Mr. LaPella just raised. As to the characterization of a luxury lifestyle, we don't have to argue over that. That is what it is. You can characterize it as we go through it, and I'll make a determination of whether it's a luxury lifestyle or a middle-class lifestyle or whatever. I don't think so. The other issues is, I think, where you state that there's no record that any of the money she embezzled was used to support her family or housing. That's a statement, and he can test it.
That's an arguable statement. I mean, to go to the movies and go eating, is that supporting the family? Yes. Is that supporting the family in the sense of I'm buying diapers that are necessary? No, I think that's an arguable statement. Judge, that's where the state would stand on that.
Sound like a lawyer there. I don't know.
Sorry, but that's... That's the answer.
Okay, so, I mean, that is what it is. You all can characterize how that money was spent, and I'll make, the characterization of it is less important than actually what actually happened with it, which the court can evaluate. And then there was a third thing too, and that is the foreclosure. You're basically saying the foreclosure happened before all this started? Is that your argument? So this shouldn't be considered, shouldn't
It shouldn't be
really
considered some
talked
type
about?
of aggravating circumstance that my client's berated for not spending money on her, saving her home that was foreclosed on. I just think that it's basically, and no offense to the probation officer, I know they're trying to do the best they can with the information they have. I want to preface that. I'm not trying to be overly critical, but it's improper to speculate that that's a negative quality on her character, that she didn't spend money on her home and to save her home when that wasn't even possible. So I don't know where that information came from, but we'd say it's not a proper characterization or a proper judgment, nor was it even possible. So I'll just leave it at that.
I don't intend to harp on that or mention it at this point, Judge. My understanding is it happened beforehand. I've talked with them and don't think any of my witnesses really know much about that, quite frankly.
Okay.
So.
Well, I'll assume that's not going to be emphasized, and we'll proceed. Okay. Anything else, Mr. LaPella?
Only a judge that, we were asking for.
As it relates to the
departure.
PSI.
Not on the PSI. I think that covers it, Judge. Thank you.
Okay. You want to make an opening statement? Do you wish to just start calling witnesses and say for closing? It's up to you. You can make a brief opening statement. The court's reviewed the documents, and you can proceed as you wish.
Just to make sure you've reviewed all the character letters as well from the victim and from defense counsel.
I have.
Okay. At this point, Judge, again, we're seeking 8 years. That's the cap that's set there. I don't believe there are grounds to depart. We're going to take some testimony. I anticipate you're going to hear from the victims, both of them. You're going to hear from an accountant, law enforcement regarding cooperation that's mentioned in the memo, and potentially a doctor, depending on what testimony comes from defense on this. We can start off by calling first witness of Dennis Brannon.
Hold on a second. Do you wish to make an opening, Mr. LaPella?
I would, Judge.
Before we call a witness, let Mr. LaPella.
We've provided the court with some basic facts that we think are very relevant to the issue of whether or not the court should consider departing downward below the guidelines of 34.5 months. This is a case where there is obviously criminal liability, but it's a very rare case in which the defendant went and sought out law enforcement to disclose her crimes, in a sense, and also because she was overwhelmed with emotion. And that is I would characterize it as the prime moving force that started this. She was the one who went to law enforcement. She self-reported her crimes. At that point, it wasn't really established the extent, but she did initiate that investigation. So there is a ground for departure in that regard, and that is under 921, Florida Statute 921-00262, subsection I, in which the court can find a basis for downward departure if the defendant cooperated with the state to resolve the current offense or any other offense. In this situation, we would submit that she did do that, and the facts do support it. I don't think it's really not contested that she did, in fact, go to law enforcement and made a confessional statement. So that I believe is established. We may argue about the extent of her statement, but we believe it does qualify her for a departure ground, in which the court then could depart below the guidelines and not necessarily send her to a prison. I would also just like to point out that my client sitting next to me, of course, but she also has a lot of family in the courtroom today, as well as friends. and people who support her, which basically takes up the side behind me here. There's a lot of people who care about her and are standing behind her, supporting her despite some of her mistakes that she's made. And like I said before, I do want to also preface everything I say with any challenges I have, any cross-examinations I have, I do not want that to diminish from my client's contrition and her remorse that she feels about her actions. We're not going to undercut that in any way. So, and I'll reserve other argument for later. Thank you.
Counsel for the state, you may call your first witness.
Call Dennis Brannon.
Please raise your right hand, sir. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
Please be seated, counsel.
Judge, we would invoke the rule.
The rule of sequestration has been invoked, so the rule essentially is that if you are either a witness or a potential witness in the proceedings today, we're going to ask you to exit the courtroom. The purpose of this rule is when we testify, one of the bedrock principles is that we want to testify about what we know personally, and we don't want it to be influenced by what somebody else might say on the witness stand, good or bad. And so we ask you to not only not hear the testimony, but also not talk about it. When this thing is all over with, the court's finished today, you can talk all you want. But you don't talk about it when Mr. Brandon, if he went out for a break, don't walk up to him and ask him what he testified to here today. Same goes for your stuff. So, and I would ask that the attorneys ensure that any of their potential witnesses would be excluded. And now, that does not go for the defendant, and what about the victims?
Judge, that's what I was about to mention. There is a victim that's also a witness in this case. I believe they have a right to be present during this.
I believe that's true. Mr. LaPella, do you disagree?
Is that new with the Marzi's law?
That's my understanding. I'd have to,
I think my understanding, y'all's understanding, I don't think it vitiates the rule of sequestration because the testimony of one witness could corroborate the testimony of the other, and that's the whole basis of the rule. So the right to be present in all proceedings, according to Marzi's law, as a victim, does not necessarily supersede the right to a fair trial or a fair proceeding in regard to the ability to effectively cross-examine or
Same
question
thing could be
witnesses.
said about a defendant, too. But, and I'm not saying the defendant doesn't have a right to be here. The defendant does have a right.
I can't
I don't
concede.
know.
my understanding is the victim has a right to be present. I don't have anything exactly on point on that, but that's my understanding. The victim has a right to be present at any material part of this proceeding, in my understanding. Where?
The right to be present doesn't necessarily specifically state that they have a right to be present during the time in which another witness is testifying, that they're going to testify as well in that situation. Like I said, I don't think there's anything specific in the rule, any Marzi's law, that supersedes the rule of sequestration. I don't think that's been addressed in the case law, but I could be wrong. But I can't concede it, Judge. Thank you.
You'll argue it, I'll make a ruling, counsel. It's up to you.
Again, Judge, my understanding is the victim has a right to be present. Mr. Paul Brandon is a victim as well. He has a right to be present and hear it at the sentencing hearing involving his matter.
You make your argument, and I'll make my ruling.
Good.
Your Honor, may I consult my father? That'd be admissible? Just
No objection from the defense.
Okay. careful, there's real good acoustics in this room. You need to step outside, you can.
I'm faced with this issue once before, if you recall, in depositions. Rather than create a potential appealable issue by contesting it, Paul is going to step outside.
Very good.
I want to make an argument in good faith here.
Hold on.
I apologize.
That's all right.
I want to make sure
Come on
that I'm
up
not
here.
ever producing anything to the court that's not true. I'm looking at Florida statute 90.616. I believe there is an exception, perhaps.
An exception for the rule of sequestration or
Perhaps.
the rule, the
Maybe.
Marcy's law?
I just don't want to be flippant in my objections.
I'm That's your books.
Say, a victim's parent or guardian if the victim is a minor, is a lawful representative of the victim, or the victim's parent or guardian if the victim is a minor, or a victim's next of kin, may not be excluded from any portion of any hearing, trial, or proceeding pertaining to the offense based solely on the fact that such person is subpoenaed to testify, unless upon motion the court determines such person's presence to be prejudicial. That's under 960.001 E3.
So
I'm not sure if the rule says.
we read the statute, so
Yes,
are
ma'am.
you, does that, and you brought it to the court's attention, Mr. LaPel, are you conceding?
Reading the statute, I'm trying to be thorough. It just says the court has to make a determination of whether or not it's prejudicial to the accused. I think in this situation, we're going to waive it just because I don't think there's a situation that I can foresee that's going to lead to prejudice against my client. So I'll just waive it. Thank you.
Very good. He's withdrawing it. It's up to you if you want to stay or go. Counsel, you may proceed.
Would you please state your name for the record?
Yes, my full name is William Dennis Brannon.
And Mr. Brandon, what do you do for a living?
I'm an attorney.
And you own your own firm?
Actually, my son and I now own the firm that's commonly known as Brannon and Brannon.
And where's that located?
We have offices in Defuniak Springs, Destin, and Fort Walton Beach.
And how long have you been in the community practicing law?
In this community, I came here in 1979 and started to practice law.
And how's the firm done?
It's done very well.
Do you know the defendant, Janice Porter?
Yes, I do.
How do you know her?
I know her from work. Go ahead, I'm sorry.
A second. When did she begin working for you?
Well, I seem to recollect around 2010.
How many people were working for you at that time? You recall?
We're a very small law firm. It was my son and I as attorneys. We had, I think, 2 paralegals. We had Miss Porter, and we may have had a third non-attorney person working with us.
What was the defendant's duties then?
The defendant's duties were, at the very beginning, to basically manage our accounts, bank accounts, credit card accounts. She was a bookkeeper for the most part. She was not a CPA, and her responsibilities were to maintain the integrity of those accounts. A credit card account, the legal account, she had nothing to do, as I recall, with her trust account. With our trust account, she had to pay bills. She was charged with the responsibility of looking for charges that weren't appropriate or inappropriate, bills that were not appropriate or which were inappropriate, and bring those to our attention. And she had a few office management responsibilities.
How did she do at her job?
From what we knew, she did good.
Did she acquire any new duties as time passed?
Over time, more or less, the bookkeeper responsibilities remained the same, but we actually allowed her to handle several personal injury cases in conjunction with the attorneys, and she was, more often than not, a bonus for the work that she did on those cases. There were not many because we had 2 paralegals.
Do you know how much? I'm sorry. Do you know how much she was being paid at the time?
Well, Paul would know better than that, but I think maybe the last year we looked, her salary was 47, maybe 47 and more with bonuses. That would have been in 2019, I believe.
With these responsibilities, did you trust her?
We have to trust people in your office. You can't constantly, worry about is a bill appropriate, is an overcharge, is on somebody else's case. You have to. You're as attorneys, you work and handling cases, and you've got to trust somebody to look out for your interest in handling the financial matters.
What funds and accounts did she have access to at the firm?
Accounts? Well, the only 2 would have been our legal, what we call an operating account, and then she had in 2010 up until I think it was 16, she was responsible for looking at our credit card account, which was Chase. It was an office credit card.
And she managed those payments and accounts? She had a function to do that?
Yeah, well, you're asking me if she did. I'm telling you, to our knowledge, she did.
Did she manage QuickBooks or any of those other?
Yes, she did handle QuickBooks as well.
How did this arrangement work out for the office?
Well, it worked out the way it should. If you're in a small firm, it frees you up to be an attorney. The other people in the office can't be an attorney. So every hour, the attorney doesn't have to worry about administrative or clerical duties. It's an hour of time that they can practice law. So it seemed to work.
Since 2010, you had an observation of her work ethic and how she was performing. Were you aware of any issues?
No.
Did you witness any risk-taking behavior or anything of that nature?
No, if I'd witnessed that, she wouldn't have worked for us anymore.
Any anxiety or anything affecting her work?
No.
Her work, did it involve laws and rules and following guidelines and those sort of things?
Well, there were what I would call non-published guidelines. I mean, it's not like we had as I experienced in the military, a standard operating procedure or manual that you were to follow, but it was an understanding over time, working with us, what the rules were and her duties and responsibilities were.
You ever recall having to discipline her for anything?
No.
In your mind, was she a model employee at that time?
Yeah, I hate to use the word model. I considered her a good employee based on what I knew.
And at that time, would you have written her potentially a recommendation letter without knowing what else is going on?
Certainly.
Did you later become aware of criminal activity by the defendant?
Yes.
And when did this occur?
That's kind of a long story. If the court will indulge, I'll share what happened. Late March, it had to be a weekend. I either got an email or text from the defendant that there had been an alleged data breach that involved our legal or operating account, and that she had, if I seem to recall, purportedly been notified of that by a vendor. And I remember the message was, we've got to move quickly, freeze accounts. You've got to go with her, up to Crestview, to the Regions Bank that we had never, ever done business with before. Not Regions, but Crestview. We did all our work in Fort Walton Beach with Regions. And so, it was quite concerning. She asked for a copy of my driver's license. And somehow or another, I think with my wife's help, we scanned my driver's license and sent it to her. I got to work Monday morning, and Paul was in a meeting with her. Doors were closed. And I came in, and all I can tell you I know is that And this comes from what I heard then and what I have learned from watching the statement she gave to the sheriff's deputy and reading the transcript of that statement. She had concocted a story, the story that I just gave you, that there had been a data breach and that basically our operational account had, I don't want to use the word pilfered, but it had been basically reduced to the point it wouldn't even cover our operating expenses. And the problem with that was that when I went into the room, in the conversation between Ms. Porter and my son, she admitted to lying, that was a lie. Every bit of it was a lie. That there'd been no data breach, there'd been none of that to cause us concern. She didn't go any further than that. Once we knew she was lying, she decided to get up and leave our office and basically resign. Gave us our key, left. Regrettably, she had already wiped her computer clean, so we were not able to retrieve any information relating to what she said. Now, there was a text after that when she left our office that she sent to Paul. We have that text. It's been saved. I'll be glad to publish it for the court.
May I ask Mr. Paul or Brandon about that?
Okay. Well, I will just say generally, and he can publish it, but she admitted to lying. She admitted that the whole story was a lie, that she had stolen from us. And she said that she had no excuses or any justification for that. So that was the next thing that happened. And I'll continue on about the events of that day. These were April 1, 2020.
There was, you later reviewed the records that what she was saying was that most of them, she was actually taking most of this money. Is that correct?
Yes.
Put it this way.
The majority of the money that was stolen from us, either from our legal or operating account or by illegal and improper use of our Chase credit card, went to her or for her benefit.
Did you review those bank records, or was that Mr. Paul Brandon that reviewed them?
Well, actually, what happened was I focused in on the Chase credit card, and I mean, that deserves a word of explanation before I go further. We're in 2020. Long before that, we actually have an email. Paul had decided that we were going to terminate the Chase credit card and go with another credit card. I believe that was in 2016, I think is when that happened. I've actually got the date written down somewhere in here. But I actually had my card cut in half. It's sitting in a notebook back there that I cut in half. And when that decision was made, Paul destroyed his card. The defendant did not destroy her card. She had the third card. And what we found out over time was that she was using that card almost exclusively for personal purposes. I mean, well, absolutely for personal purposes, most of which were purchases I can talk about in just a minute if you want. I actually have the Chase credit card statements in a notebook, and I did a summary for the court of the things that she purchased using the credit card. So much more was discovered. Paul was in on that. He actually took a look at our bank account, and I can go into detail about the involvement of another person who we're going to hear about at some point, Mr. Morgan, if you wish. So,
and that's what I wanted to talk about. There was another individual. You talked about the data breach, just to clarify some of that.
Yeah.
It wasn't a data breach, but there was someone that had access to the account that was also notified. Yeah. Can you explain to the court what was going on there?
Yeah, Judge. What had happened was that I think starting as early as 2013 or thereabouts, Ms. Porter began to use our legal account to pay off her credit cards, to pay off debt she had. And somehow she was able to manage. I mean, we were receiving money in. She knew how much money we were receiving in. She could draw money out of our operational account and use it to pay off her credit cards or pay other debts that she had, until, lo and behold, something happened. There was a gentleman by the name of Mr. Morgan, who, beginning several years before April 1 of 2020, several years, he somehow penetrated our legal account, and we finally got a hold of our bank statements, which were being diverted to her by her. We never saw them. And you could see where he was using our legal account to pay loans up in Georgia on cars, on college, all of that. It was obvious that somebody was stealing from us. And what Ms. Porter has admitted to doing was she covered up that. She hid it from us. She had to hide it because she couldn't bring it to us. Because if she brought it to us, she would disclose her own theft. And so she allowed this gentleman to basically pilfer through our legal account without sharing that with us for several years, until apparently Mr. Morgan decided, well, nobody's going to stop me. The alarm's not going to go off. Nobody's going to ring a bell. So according to Ms. Porter, in a statement she made in January and February of 2020, he decided to dig deep into our legal account. Now, she knew he was stealing all along for several years.
Speculation.
It's not,
You need to direct the questioning.
Yes, Judge.
okay.
Well, let's go back a little bit on that. We're talking about this, you talk about the Jane Morgan, the data breach issue. She asked for your driver's license specifically to go change the accounts. What was the purpose in that? Why didn't she, in your view, would she require that?
I really don't know. I mean, but at the time, it was frightful enough to send her a copy of my driver's license.
If you had looked at those records, you personally, you would have noticed in fact, you later did notice that it's going directly to her credit card payments.
Yes, and we would have noticed from our bank account statements that money was going out of state to Mr. Morgan for various purposes.
And had you ever discussed with the defendant before about theft cases in the community and how that is treated?
Yeah. Yes, I'll share with you. At least a year or two, maybe more, before April 1, I had a very dear friend come in my office who, she had a bookkeeper who had stolen from her escrow account as a realtor. They came in my office to seek my help. I won't mention their names.
I don't think this story about a tangential friend or a relation is relevant to this proceeding.
Let me draw him in closer to the exact question on that.
I'll allow him to go a little further because, go ahead.
Did you ever explain to the defendant punishments that happen for thefts in situations like that specifically?
I made a point to go to her specifically and tell her what had happened to these people, and that this person who stole from these people who were members of my church, that she was going to jail and prison for what she did, and that was appropriate. And then there was a second time before we discovered her theft where a local attorney had a bookkeeper that also stole from him. And I took that information to her a second time and told her, this is wrong, this person is going to be prosecuted, they're going to do jail time. Now, having shared that information with her, nothing changed about her behavior. She continued to steal from us.
Did you seek outside accountants to look through your books?
We had our own kind of accounting group that did our tax returns several times. We asked them to come in and look at our books.
Was there a report prepared?
No, there was no report. They just said they couldn't find anything.
Oh, well, going forward, after you had these discoveries, did you hire a forensic accountant specifically
that was
to
at
go
a different
through?
time, okay. But, yeah, we did. We went into, once we learned this happened, I knew of Stephen Riggs' firm, and I knew they did forensic accounting work, and we hired, Carr, Riggs, and Ingram, particularly Ben Kincaid, to come in and do a complete forensic audit.
And they had prepared a report?
Yes, they did.
You've reviewed that?
Yes, I am.
We'll probably just get into that later on with Ben Kincaid. How has this affected your firm?
Well, it was, how do you put it? It's kind of mind-blowing in a small business like that. Anybody that's ever practiced law and had a small firm, to have someone that sits at the table with you that's considered a friend as well as a coworker to do something like this. I'd never, ever experienced anything like this. I mean, I practiced for 40-something years, and I never knew anybody to ever take a penny from our business that they didn't earn. So it was, the initial response was, what are we going to do? We've got overhead, we've got bills to pay. We ran around, we went to our bank, they made us a loan. But, you know, it was not knowing the length and extent of this that was worrisome. I mean, we really began to worry about our clients, you know, our cost money. You know, had something happened that may have affected a client adversely or something like that. So we got that forensic accountant in there right away, start working on it, and we patched the holes in the boat to keep going. So,
Did it affect your firm's reputation in any way?
well, not until the charges were filed, and then people noticed that. The other thing is is a trust element. I mean, and since we discovered what she did, Paul personally has been doing our books. I don't believe in my career show that we'll ever hire anybody to do our books. We just don't trust someone. But you cannot run a law firm without trusting people. You have paralegals that you have to trust to file documents to make sure that, you know, things are done properly. It is a trust organization. And you don't have that same trust. I find myself back-checking on people now more than I ever did to make sure they did what they told me they were going to do.
And you've reviewed some of these character letters as part of the PSI, is that right?
Yes.
And previous to finding out this information, you would probably be in agreement with a lot of those letters. Is that a fair thing to say?
I could have been one of the ones who wrote a letter of recommendation, but on those letters, those people don't know. They have no clue. And obviously, the defendant did not share with those people the information or the detail on what she had done. And I will tell you this, I might have written her a letter initially, but if I had found out what she did, I would absolutely not write her letter.
Were you ever received any compensation back from her in regards to this? That's a no?
Nothing. And by the way, we have no need for restitution in this case. I want to make that clear. We have, from the very beginning, when people reached out to me about that, I made it clear this case is not about restitution.
Just to kind of clarify some of that, how is your firm doing now?
We're blessed. I mean, God has blessed us
Are you solvent? There's no financial issues or anything?
more than solvent. We're doing better than we ever had.
And so in your opinion, the need for a prison sentence doesn't outweigh, or I'm sorry, the need for a prison sentence does outweigh any need for restitution.
Absolutely.
You don't need it to pay out, the bills, get the lights on, to worry about bankruptcy or those kind
No,
of things.
we took care of that. And like I said, I really believe what I said is that it was amazing after this happened to us how things came to us, money from different sources and files and cases and that sort of thing. And so, no, it doesn't even enter into the equation for us.
You're a victim in this case. You have a right to be heard at sentencing and be present. Is there anything that I haven't asked you that you want to let the judge know in regards to sentencing?
Yeah, I have heard from the motions filed by the defendant's attorney, I've heard two things, mainly. Restitution, need for restitution, and I hope I've made that clear. We have no need for restitution. And that is based on our financial situation. The second thing is cooperating with the state. I won't characterize that, what I think about it, but I will tell you about what I've observed about her cooperation. Yes, she went to the sheriff's department. But when she went to the sheriff's department, she didn't tell the deputy the truth. I obtained the videotape of her statement and had it transcribed. I've listened to that videotape 2 or 3 times. And if I may, I want to, knowing how much she's stolen over what period of time, I want to share with you what she told the investigating officer that is a fabrication. She said she'd only stolen for 1 year. She'd only stolen $5,000 a month. She'd stolen less than $100,000. She did admit she started slowly, didn't get caught, and increased her theft over time. She also was truthful when she said she used the Chase card to steal, and then she'd pay the card down with funds that she stole from our legal account. She said she had only known about Morgan for 6 months before he came in and basically obliterated our legal account. If you look at the statements, she knew about him for years before this happened. Now, she admitted in her statement to the deputy, she hid the theft by Morgan. She specifically said that. She just hid it. And it was only when she realized she couldn't continue to steal in view of the damage that Mr. Morgan had done. She couldn't hide her theft. That's the only reason she went and turned herself in. We were out of money. There was no more money for her to steal. It was gone. Morgan took care of that. They had depleted the account. Now, some things she did say that I would ask the court to consider is, I know where we are now, but I know where she was on that day. And on that day, she said there was no justification for what she did, that she is totally guilty. It says that what she did was wrong, and she said, I'm not asking for any forgiveness or mercy because none is deserved. That's out of the mouth of that defendant, you know, as compared to what we're hearing now in the courtroom, which is diminish, forgive, you know.
Talk about the cooperation. She never came back and helped you sort out the finances or?
Never.
Leading.
Okay,
Did she ever come back and cooperate with you?
no. No, we never got any information at all from the defendant that would help us determine what had happened, how it happened, what accounts were involved, how much, vendors she purchased from. We had to go pull all that together ourselves. And in my victim impact statement, I pointed out to the court, we probably spent over $100,000 just trying to reconstruct what she did. And the attorney time, and I know from testifying as an expert witness on fees, the attorney time we've had to spend in this case, just sorting out what she did, is probably $200,000, $300,000, $400,000 in value. Those are additional damages to us, over and above. We keep talking about $300,000. That doesn't take into consideration the damage that she did to her firm, that we had to spend money, take time, effort. I'm sure we're going to be talking about the civil suit. We had to issue multiple, hundreds literally, production non-party subpoenas to vendors just to find out and confirm she did this, how did she do it, and that sort of thing. I mean, the workload was just incredible in terms of the effect on us. It took away from our practice for probably 3 or 4 months, and I can't imagine how much total. But
Given all that, what kind of sentence do you want to see from the judge?
well, 8 years. 8 years. Frankly, I consider her attorney has done an excellent job reaching that point. And while we may want to not talk about it, it could have been much, much worse for her.
Objection, speculation.
Much worse. So, okay.
That's all the questions I have at this time. Mr. Lapel is going to ask you some questions. Just answer those directly.
Yeah, Judge, I know I get these questions, but as a victim, I'm allowed to make one small, short statement.
There's something else that you wanted to let the judge know?
Yes. Yeah. Judge, the reason this is so troublesome is, in part, Mr. Lapella's motion actually has a paragraph that says that somehow, perhaps the theft by this person is justified by the amount of money they helped us make. And I want to make sure that he knows I repudiate that statement. That is offensive to me as a victim, that somehow the argument could be made that someone can steal from an individual because they're helping them make money and do their job. But it's like, it's almost like not everyone who comes from a difficult background or has problems will resort to stealing. There's a short story, if it'll come to me. My dad and my mother both served in the military. I had the luxury of being in Germany with my dad when I was 10 years old. I found money on the sidewalk. I took it home. My dad came home in his uniform. I mean, and you got to understand, my dad, he was, what's the word, difficult to live with, but he also only went through the 6th grade. His father died when he was 12. He grew up in Mississippi, poor as dirt. And he went in the service, Battlefield Commission, Silver Star, Bronze Star, went all the way up. He retired a lieutenant colonel. But he grabbed me by the hand that day in Germany, and he walked me down to where I found the money. And he says, "Dennis, this is not yours. It will never be yours." And so he had me go and find somebody who would hold that money and see. And I thought to myself, it doesn't matter how hard your life has been. There's no excuse for stealing from somebody who looks after you, pays you a salary, pays you bonuses. I think Paul will testify that probably never a time she came to him and asked for a raise or whatever that he didn't give it to her. And so that's what offends me the most is, you know, there's no diviner of honesty and integrity that relates to your economic situation. I mean, if you can't afford something, you do without it until you can afford it. But to go to these places like Lululemon and restaurants and splurge in one day $1,000 buying stuff, I mean, the Bible tells us about that sort of thing. Why waste your time on gold and silver? It will eventually rust and corrode. It's all about your integrity. And so this will hang around with me probably for the rest of my life. So.
Thank you.
No questions, Judge.
Thank you, Mr. Brandon. You may step down.
Thank you.
State will call Paul Brannon.
Yes, sir. We'll come around. Brandon, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Please be seated. Counsel, you may inquire.
Thank you.
Would you please state your name for the record?
Christopher Paul Brannon,
And Mr. Brannon, where do you work?
Brannon and Brannon, as a partner with my father, Dennis.
Okay, and that's the same firm that we talked about. And,
Correct.
do you know the defendant, Janice Porter?
I do.
And how do you know her?
She was introduced to me by Kristen Beaujolais when we were looking for a bookkeeper, and we ended up hiring her part-time as a bookkeeper in 2010, I think it's September.
And I think we got some of this from, but I just want to clarify. You kind of handle more the day-to-day activities and management. Is that kind of a better way to put it?
Yeah, when I started, it took a few years, and then Dad said, you need to learn how to do this, so pick up the tools and start learning, so.
Okay. So did you observe Ms. Porter's
Daily.
activities? Daily?
Daily.
And how did she perform in her duties?
She was good. She did everything that we asked for her to do, and it was in a timely manner.
Did you have trust in her?
Obviously, when you're letting somebody do books, it was a building trust. I remember first she didn't have signatory rights with our operating account, and everything had to go through either me or my father, but over years, she did build that trust up, and we gave her the right to sign checks.
And going back, you dealing more with the business end, what kind of accounts did she have access to and credit cards and those sort of things?
Right, so no access to the trust account in the sense of she couldn't sign trust checks. She could run a deposit for a trust check. She did have signatory rights with our checking account. We don't have anything like a savings account. We don't have a debit card. And then we had the Chase credit card, which converted over to a Capital One card, I think, in 2016.
And you specifically canceled that card?
Yeah, it was after speaking with my dad, we just wanted better points, and actually Janice helped us find a credit card that had better points, and she was specifically instructed to cancel that. And she sent an email to Kristen Beaujolais, one of our paralegals, and Ashley Armacost, saying that you need to switch this particular vendor account over to the new credit card. It's the last one that keeps showing up, and then they're canceling it, and then she's going to cancel it. So.
Did she have any access to QuickBooks and basically putting, handling the accounts in, accounts out, those sort of things?
Right, so she worked at her own desk. She had a tower, a desktop. That desktop was the only desktop that had QuickBooks on it. There's nobody else in the office that even knew how to work QuickBooks. Much less, I had a hard time even finding her password to get onto her computer because every station had its own password. So she was the sole person within our office working on our QuickBooks.
Were you aware in observing her of any risk-taking behavior?
No, I mean, she never came to work drunk, high. I've never saw her gambling. She never did extreme sports or anything like that. And as my dad said, I agree with him. Had she exhibited those behaviors, we would have let her go quickly.
So did you ever discipline her for any issues?
Not at all.
Okay. Did you have any knowledge of any anxiety or anything else that she was experiencing?
Not anxiety. I know just from talking to her and the staff that she regularly took Adderall on a daily basis. I think her doctor was Dr. Tidwell that she told me, and I think that was for ADHD. So I think from the time that she was working, she had been on Adderall for years.
Did you ever notice any effects on her work product or daily activities based on that?
No.
In your mind, was she a model employee?
On the surface, as far as I knew at the time, correct.
And similarly, you would have probably written a recommendation letter.
On the surface, at the time, absolutely.
And then later, you became aware of criminal conduct as well, is it?
I did.
Explain how that happened.
Correct. So just a preface, as my dad was saying, late March, she comes to us, says that there's been a data breach with a vendor. Our account information has been shared or there's been money stolen. So obviously, what she's doing is saying everything I want her to say. She's like, I'm freezing the accounts. We're doing Regents meetings. And, I need your driver's licenses. And then that's when the weird stuff started happening.
Why did that make you feel, you felt weird? Why?
The weird was the Crestview. We didn't have an office in Crestview at that time. We didn't bank in Crestview. It's always been in Fort Walton. And I just flat out refused. I said, no. I said, I know Kathy Hillman at Regions. She is my go-to office or Regions manager. And so I scheduled a meeting with her end of the afternoon or mid-afternoon on April 1st. So these conversations were going back between me and her we were talking, texting, or emailing at the time. So April 1st, I get into the office. We're having an office meeting. I'm talking to the paralegals, trying to get them set up on the caseload that week. And right before they come in, she says, Paul, I need to talk to you at the end of this meeting. I said, absolutely. Just thought it was a standard business talk. Well, she has 2 envelopes in her hand after the paralegals leave. She hands them to me, representing to me that there are January and February of 2020 Regions bank statements. And she flat out told me I lied about the data breach. And she says, but somebody's been stealing from your accounts. And I think she said she may have been scared to tell me. So I open up the bank statements, and her name's going all the way down from the top to the bottom, and they're all ACH transfers. Essentially transfer of digital currency from our bank to these other vendors. And almost every single one of them, except a few that were our Brandon and Brandon vendors, her name was on the side. And I just showed it to her. I said, Janice, this has all your names on it. And she refused to accept that was her. She kept on telling me, no, that's not me. No, that's not me. No, that's not me. I didn't steal from you. And at that point in time, I think it got kind of blurry. I yelled at screamed for my dad to come in. And he didn't say a word during the rest of the meeting. He's almost in shock. She ends up handing over keys, passwords, and leaves the office. We tell the office she's gone. She's not allowed to have access. I'm calling my IT guys on the phone, freaking out, saying you need to block her email. And her email's on everything, because she's managing vendor accounts for us. So I immediately call the IT guys, try to close them out, advise the staff that she's not longer permitted on premises. We call Stephen Reeder, our accountant, immediately go over to him. On the way, I'm calling Kathy Hillman at Regents, saying I need to meet with you sooner than previously scheduled. And while I'm sitting there at the table with Stephen, I get that text message that y'all were talking about.
Going back a little bit, you had to confront her about her name being on the bank statement.
And she continued to refuse that it was actually her stealing, which in fact, later on, I personally was able to correlate the money leaving our Regions account and dumping into her credit lines with 4 or 5 other credit cards, which we subpoenaed those records, and I personally verified the amounts and the dates, because actually Ben didn't do that. Ben looked at it and was able to, isolate what she had stolen, but I looked on the back end. And that's what's so frustrating about this, because just for the ACH transfers from our account to her community bank account, Synchrony, she had Disney cards, she had all this stuff. I mean, it literally, I'm sorry, I can't remember all these, but just the bank disbursements to her credit lines were $220,000. And that's just one way of how she was stealing from us.
We'll probably get into greater details on
Sure.
that, but I know you personally reviewed some of that as well, as you mentioned.
I reviewed all 6,000 pages that came into my office, if that gives you any idea of how many hours I spent on this, for the past 2 years.
Did you find out later that she turned herself in?
So we were at Stephen Reeder's office, our accountant, and she sent the text advising us. I think the first statement was, "I'm sorry."
Well, what I may just,
Sure.
if I can approach with the state's Exhibit 1. Same message. I may approach, Judge.
Me.
Can you identify this?
Yeah, that's a screenshot from my cell phone that I saved, provided to your office, and that is from Janice Porter's phone number, and she was texting me.
And how do you know that?
Well, because I've seen this too many times, and I still have it on my phone.
And she texted you from that number previously?
Yeah, ever since she was been working for us, yeah.
And based on the content, it was based on the conversation previously.
It all seemed relevant to what was going on at the time.
They would like to move Exhibit 1 into evidence.
LaPella,
No objection.
without objection, the court will admit Exhibit 1, State's Exhibit 1.
We can talk about this a little bit. You just read it into the record for the most part.
Be glad to publish it.
It would probably publish it to the judge as well, but read it in the record if you can.
Yes, of course. I'm sorry, you and Dennis do not deserve what I've done. I'm at the sheriff's department and I am turning myself in. I just called and told Ben everything. He did not know anything. I can't face my family. Turning myself in is my only option other than killing myself to make this all go away. I can't live with the shame and regret. There is no excuse to justify my actions. I don't deserve your forgiveness or mercy, so I won't ask, but know that I regret everything.
Publish that. If you want a copy now or...
Thank you.
Did you conduct further investigation into the accounts and hire an outside auditor?
We did. We went to Carr Riggs Ingram, Steve Riggs and Ben Kincaid came to the office and we retained them. And they've done, a very, very thorough forensic examination of all of our books, QuickBooks and our Regions bank accounts.
Your knowledge, what was discovered in regarding to the time period of this theft?
It started 2013. Unfortunately, because people don't retain records more than 7 years, we could only go back to spring of 2013. But almost the first record we found in 2013, she was writing extra paychecks to herself, and she was writing checks, just straight up checks in her name to herself, which she later either voided, deleted, or changed the name on the check when she saved it back into QuickBooks.
This is in excess of 300,000? Without getting into any other numbers there, is in excess of 300,000?
So actually, extra payroll was small. I mean, I say small in light of the total, but it was $3,708.
Objection non-responsive.
Ask the question again.
This was in excess, the total is definitely in excess of $300,000 of the theft that she's
So the answer is yes.
this wasn't some isolated incident. In other words, it didn't occur from one grand taking of money. It occurred over the course of months.
Objection leading.
How long did this occur, and was it isolated?
It was absolutely not isolated. I personally went back and roughly calculated how many transactions Janice actually made when she stole from our office, and it was over 2,500 different transactions. And if it gives you any idea, 7 years is 2,555 days. That means on average, she stole from us every day for 7 years.
Did it require some sophistication to cover this up?
Absolutely. Now that I know how to operate QuickBooks, probably to more than I really want to. But yeah, absolutely. I mean, from the point of deleting, voiding, renaming, reclassifying, because when you put in, and I hate to kind of jump off here, but it's her responsibility as our bookkeeper to reconcile every month. You take the bank statements, and it has to balance, meaning you start with the money that you had in the account, and you have an ending, and in QuickBooks calculates the difference. And all the numbers have to match up. So if she has something on there that she stole, how is she going to classify that? We don't have an employee theft, category. So she literally had to find different categories to put this in. At times, the values were too large. So what she'd do is she'd chop it up and have it in two different categories with two different people that they were paying. And the numbers she chose were numbers consistent with vendors, like what we pay certain vendors. So this goes on and on for over 2,500 different times. So when I hear that she was working late and performing extra work, yeah, she's right. She's not lying about that. She had to come in on nights and weekends to basically cook the books.
Objection speculation.
Did she delete computer history, or did you find during your discovery that there was other concealment methods that she took?
So I apologize for my dad. He's not technology is not his thing. She deleted her search history, okay? And I later found out that she was trying to find James Morgan. She actually left a LexisNexis search in her desk where she was searching for James Morgan during that time frame. I'm not going to speculate as to why, but I think that there's a reasonable reason why she was looking for him.
Were bank statements missing that you're supposed to keep in your records?
Yeah, so we keep 7 years. Some of them were in off-site secured storage, but we did keep several years. And my associate Luke Clark and I dug up every statement we possibly could, and unfortunately, we were not able to find numerous statements out of 2019, which do not leave our office. They're always in our back storage area.
And you reviewed these. The bulk of these unauthorized purchases, what were they attributed to? What was she spending on?
So all the bank disbursements, the ACH transfers from our account to her credit cards, they were to pay off her credit cards, and we got her credit card statements. Again, I told you, they match up every time. But if you see where she's eating, where she's going, the concert she went to, the vacation she took her family on, the Christmas presents, the lavish Christmas presents, the Lululemon that she put her daughters in, it wasn't medical bills. It wasn't, I never saw anything paying down the mortgage, or a sick aunt that has cancer or something. It was literally high-end clothes, big-time food bills, and their shopping sprees, as my father discussed. It was large, just multiple purchases on one day in Destin. So no, I did see some utilities, some Cox bills, but that didn't even equate to 20% based on my review.
And you've reviewed these body cams and other conversations she's had with law enforcement. Was that accurate to what she told you at the time?
No, and that's kind of,
It's not accurate to what, or is it accurate to what you
I,
found
I,
out?
I don't want to use the word lie, but I can't find any other word. She flat out lied to the officer when she turned herself in. And
Objection. I didn't quite hear what he said, but I think he, isn't it?
I said she flat out lied to the officer, and I was about to explain why.
Well, could I approach, Your Honor, with the state? Just briefly.
Certainly. Did you review any body cam footage?
I did, and I read the transcription of that a court reporter stamped.
Based on that, what you saw there, and based on what you saw in the records and what she told you previously, was she being completely truthful to the officer? Or
Absolutely not. It's the records that we have in our possession that Ben Kincaid has reported that we have combined into binders and compared to her own personal records. It's absolutely not truthful. She said she was only stealing for about a year at $5,000 a month. That's $60,000, okay? It's obviously much larger than that. And I understand and Your Honor, you have to tell me to stop, but I understand what you agreed with her about what the restitution is. But my father got up here and testified under oath that he believes that the theft was in the $600,000 range.
Objection.
Well, this is relevant. Sorry, Your Honor.
Objection, Judge.
Wait, what's the objection?
The objection is, can I approach?
Did the defendant ever come back to you and assist you in sorting out these details?
Never.
Did she ever cooperate with you or to law enforcement to your knowledge?
She never helped us.
Did she ever compensate you, give any restitution back to your knowledge to make up for this theft?
Never.
How is your firm now?
As my dad, I would agree with everything my father said about that. We're blessed. We're prosperous. We've had an incredible past 2 years. We even had a pretty darn good 2020 because we had some decent cases settle. But we are debt-free. Our accounts are up to date. Our staff is paid. All our bills are paid. We have a large amount of money in our checking account. We don't need the money.
And I'm listening, and there's a lot of emotion that's going on. To my understanding, is it about the money, or is it about a trust element? Is there something more that's been stolen from you in this regard?
For me, it's a trust element. I was going to get into this, but, obviously I think her theft hit us on a lot of different planes. There's a social element, there's a psychological, there's even a physical. On a social element, I can't count how many times my friends or even colleagues or peers in the legal community, I had to explain to them what happened and how we are doing and what's going on. Professionally, I had numerous clients asking me if their money's protected in our firm. And that is a stressful moment when you're trying to not only give them adequate legal advice and representation, but now they're questioning you. The client-attorney relationship is built off of trust. If they don't trust you, you don't want them as a client, or they don't want me as their attorney. So I had to repair a lot of that because it was in the news on social media and everywhere else. The Florida bar came knocking. I've never been reported to the Florida bar. I don't know of any of times my father has. The Florida bar has never slapped us on the wrist for doing anything wrong. We've walked the line with the Florida bar, but we got that call, and my heart was beating about as fast as it's beating right now. Luckily our trust was never touched, but for that moment where we don't have a forensic accountant telling us it hadn't been touched, and the Florida bar, calls you once you do have that confirmation it hasn't been touched, you're thinking, oh man, I'm going to be suspended. I'm going to be reported to the Florida bar. And actually, somebody out of, I think she said Pensacola, reported us. So that shows you how far this story went in a very short period of time. There's the public perception of, what people see, how they see us now. And if I may, can I just read some of these statements?
Yes.
I'm going to do it now or do it later.
If there's some statement that you want to let the judge know about.
I do. Do not want to do business with that incompetent law firm. Shouldn't take $700,000 for someone to notice. Why don't they review their financials? Can someone tell me the name of the firm? Want to make sure I don't ever hire lawyers that can't even keep track of their own money. How much money did the lawyers steal? She should have never been handling every aspect of the dealings with the financial side of this firm. A thief stealing from thieves sounds like karma. That is just a few of the statements that were made in public, like in social platforms, about our law firm. And it's crushing because of what I see my dad built over the years. And now someone like this can cause this much damage to our reputation. A lawyer's only as good as his reputation. I think my dad even kind of mentioned that. So that's social and professional. Me personally, I was affected a little bit different than my father. I got kind of hit psychologically with this. I stopped trusting anybody. I had a lot of anger issues at the house. There's a lot of late nights, stress, with the encouragement of my wife. She sent me to counseling. I've always suffered from anxiety, but this just sent it through the frickin' roof. But I'm doing better. And physically, my dad tells me I inherited the stress factor and the stomach problems, but there was times where I had to go to my doctor, my family doctor, and get prescribed medications for IBS and acid reflux and all kinds of stuff. So this isn't money, okay? It's Dad and I, like I said, we're blessed. What she did to us, she took things that we can't get back.
What sentence would you recommend to the judge?
There was a lot of times I didn't agree with your plea agreement. I still somewhat don't agree with your plea agreement. I'm not going to speculate as to what a jury would do, but if there was an option to give her more than 8, I'd give her more than 8. But right now, sitting here today, I think 8 is the only option it's the fairest option of what's available right now. I do want to say one thing. You're about to ask me this question. Do you have anything else you want to add? That's what you did with my dad. I'm going to assume it, so I'm going to make this statement. I'll stay away from the amount of money. I am concerned that as a victim, I can't tell my side of the story and how it's affected us because the state and the defense have entered into an agreement on the amount of money. So I feel like my victim rights are being, are being taken away. But I will say one thing about what she said to the officers when she turned herself in. She knew about James Morgan back in 2017, and that is not speculation, as Mr. Lupella objected my father, and I'll tell you why. She had to reconcile the books every month. So when she got the bank statements in and it showed, a loan to a truck or a rent payment, she knew that wasn't a Brandon purchase, and she had to balance the books every month. So she let this guy essentially steal $250,000 plus dollars when it was her job to check that for us. And as she told us right then and early on, we could have stopped his theft, and unfortunately for her, we'd have found out that she was also stealing from us. So when she told the officers that she only knew about him for 6 months, that was a lie. I can't form any other words about it. It's just a lie. And I do disagree on the amount of time that she told the judges or told the officers that she was stealing. I disagree on the total amount that she told the officers. And I think it's very clear in what Ben Kincaid is going to tell you. It's going to become crystal clear, honestly.
I don't have any other questions. Mr. Lupella may have some questions for you.
Very good, thank you. Mr. Lupella?
Thank you, Judge. Questions? Mr. Brannon, is there a civil lawsuit pending against Ms. Porter that is in Okaloosa County right now, in which you're the plaintiff?
Yes, sir.
And in that lawsuit, are you seeking money?
Money damages are what we have requested, correct?
And you're aware of this person, James Morgan?
Aware of his existence by name only.
Okay. And how much, I'm sorry, and he has allegedly stolen excess of $250,000 from your firm? That's
correct, I believe so.
And was there a subsequent investigation as to his existence and whether or not he is a real person?
You're going to have to ask Investigator Kruger regarding that. I think there was, but I can't confirm.
He's not, you don't have any knowledge that he's a real person, he lives in Georgia?
I've heard that, but again, I think Investigator Kruger would be the best person to ask.
And in your discussion with Investigator Kruger, did you inform him that you're not interested in prosecuting Mr. Morgan at all?
I didn't bring the claim against Mr. Kruger. That was my father. That was his decision.
And do you believe that asking for a lengthy prison sentence to be imposed on Ms. Porter will restore the public's trust in your law firm?
No, I'm going to have to work really hard to get that restored.
Further questions?
Anything else, counsel?
Mention of the civil suit. Is there a difference between a civil and a state proceeding, a criminal proceeding?
Are you asking me, can you rephrase?
I'll rephrase that. As you mentioned earlier, you're not happy with the way that the state has proceeded with that. The civil suits are different, is that right?
They are. The burden's different. We don't have to prove as much to get an award of damages. Your burden here in this courtroom is much higher.
The mention of the Mr. James Morgan proceeding, you don't know any knowledge about where he is or what's happened to him.
You know, the only thing I can tell you is I think Kruger said he was in jail, maybe out of jail. There's other things that he's done that he's being prosecuted for. It's all hearsay.
Have any other questions?
Anything else?
Your Honor, can I make just one comment and then I'm done? It's just a victim.
You want to let the judge know?
It's just regarding the civil suit. The only thing that I would bring the distinction is restitution. I know the court is having to weigh on this idea of weighing the need of restitution, and I think we've provided enough evidence by testimony that we don't need it. The money damages I don't need either. It's something that she legally owes in our mind. So the need versus something that's just legally owed, we draw a distinction between those two. So,
Thank you. You may step down. Counsel?
Today we'll call Ben Kincaid. I believe he's outside.
Sir, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
Please be seated. Counsel, you may inquire.
Would you please state your name for the record?
Benjamin Kincaid.
And Mr. Kincaid, where do you work?
I am employed at Carr, Riggs, and Ingram LLC.
And what do you do there?
I'm the partner in charge of our forensic and litigation practice.
What sort of education have you received?
I received a bachelor's in business with a dual concentration in accounting and finance from Pensacola Christian College, and I also attended various graduate level courses at the University of West Florida.
Spence will stipulate his qualifications.
You can inquire as you wish.
Thank you, Judge. Do you have, and I think you may have mentioned certifications in licensing?
Yes, I'm a certified public accountant. I'm a certified fraud examiner, certified in financial forensics, and a certified valuation analyst.
Do you have any other professional affiliations or memberships?
Yes, I'm a member of the American Institute of Certified Public Accountants, along with their forensic and litigation practice section. I'm also a member of the Florida Institute of Certified Public Accountants, and I serve on the Forensic and Litigation Committee in relation to continuing education for Florida CPAs. I'm also a member of the Association of Certified Fraud Examiners and the National Association of Certified Valuators and Analysts.
I think you kind of mentioned this, but what kind of work do you normally perform at your office?
So I oversee the preparation and review of forensic examinations or forensic audits, as well as various other litigation matters, both the criminal and civil settings.
How long have you been doing that?
Approximately 10 years now.
Can you kind of give for the court a difference, or describe it, I guess, the difference between a forensic audit and a normal audit? You can expound upon that?
Sure. So your normal financial statement audit is not designed to look at fraud. Fraud is considered, but its primary intent is to ensure to the stakeholder, whether that be the public, the owner, or whoever, that the financial statements are materially correct. So if you have $100,000 on the books of cash, the auditor is going in and making sure that there's $100,000 in the bank. A forensic audit or examination, on the other hand, doesn't deal with materiality. We're not financial statement audit. You might not care about a $10 charge or $100 charge. Forensic examination, we're looking at everything, whether it's a penny or $1 million. And so in that, that forensic examination is specifically geared to identify whether or not that there was misappropriation or things that were done in the books that shouldn't have been done.
So an audit was just, simplifying that, for my sake and the court's sake, an audit is just kind of make sure the books are correct. The fraud investigation is to see what's going on underneath that, if there's any manipulation and such. Is that kind of a fair representation?
That's a fair statement.
Okay. Are you familiar with this case involving defendant Janice Porter?
I am.
Did you review records in this case?
Yes, sir, I did.
Can you describe which records you reviewed?
I reviewed the financial statements for Brandon, as well as the general ledger details that relate to those financial statements, audit trail reports that relate to that. Essentially, the audit trail captures changes that are occurring in the books and records, I reviewed the QuickBooks files, and that QuickBooks files is essentially what Brandon used to maintain their books and records, payroll reports, various emails, bank statements, credit cards, et cetera.
And did you prepare a report in this case?
Yes, sir, I did.
What was discovered from your forensic audit?
Based off of the available information for our review, we identified that Mrs. Porter had misappropriated approximately $595,669 from Brandon utilizing various methods throughout that entire
Objection.
period.
Violation of our agreement.
That was attributed to her. The amount that you've discovered was over 300,000, correct?
Yes.
Looking at that, what methods were used by defendants?
There were essentially four different methods that were being utilized. The first of which was in regards to payroll transactions, where Mrs. Porter was essentially getting extra paychecks that were not authorized, and there was approximately 6 different paychecks in relation to that. There was also ACH disbursements from Brandon's bank accounts for personal credit card payments, personal cell phone bills, things of that nature. And there was 100 plus of those ACH transactions. There was also checks to Mrs. Porter herself that were deposited, and there were approximately 138 checks or disbursements related to that. And then there was also several hundred credit card charges on the Brandon's corporate credit card.
Was one of those cards supposed to be canceled, to your knowledge?
Yes, sir, it was.
Explain just briefly the ACH distribution for the court and record on that. What is an ACH?
It's an automated clearing house transaction. Essentially, what it is you go on, if you go to, say, your credit card and put in your bank routing and account information and initiate a payment on that credit card, the bank initiates an ACH transaction that is essentially withdrawing those funds directly from your bank account and paying off that credit card. And so that's essentially what was happening here, was those ACH transactions were primarily comprised of credit card payments on Mrs. Porter's personal credit card accounts.
And you reviewed those voluminous records, the business, the accounts, the bank records?
Yes, I did.
And was there a document prepared, a summary of that?
Yes.
May I approach? Approach, Judge.
You may.
Can you identify this document?
Yes, sir. This is a summary of those ACH transactions that were dispersed from the Brandon's operating bank account.
And you reviewed that and accurate, fair?
Yes, sir, it is.
They would move Exhibit 2 into evidence.
I'd like to see it again, Judge.
You may.
No objection.
Without objection, the court will admit State's Exhibit 2.
Looking through this, again, talking about the account, these are ACH transactions. These are coming from the Brandon's bank account, and where are they going, as you mentioned?
There was a Chase Disney credit card in the name of Mrs. Porter. There was a Cominty Pay Ultimate credit card that was in the name of Mrs. Porter, American Express, et cetera.
How long did that occur?
It initiated in 2013, and then as far as the credit cards, it really started being involved in the first part of 2017 and occurred until the end of our review period, which was March of 2020.
What were the amounts each month that was getting paid out of that Regions Bank account?
It increased substantially over time in the first couple years, 2013, 14, and 15, several $100s on a roughly monthly basis. Once you get into 2017, 18, and 19, it increases substantially, where you're seeing essentially tens of thousands of dollars, on a regular basis.
That's going to a personal account?
Personal credit card accounts, yes, sir.
I approach with State's Exhibit 3.
Are you offering this? Can you?
Oh, yes, Judge, if I can publish it, so the judge.
Thank
you.
No, go ahead.
Approach.
You may.
Recognize this document? Flip through it.
Yes, sir, I do.
And what is it?
These are a portion of the Chase Disney credit card statements that are in the name of Mrs. Porter.
Okay. And you reviewed that, and that's fair and accurate?
Yes, sir.
And is a certification with that?
Yes, sir, there is.
They would like to move Exhibit 3 into evidence.
No objection.
Without objection, the court will admit State's Exhibit 3.
What I'm going to do is I'm going to hand that to you. I've flagged a couple things. Maybe you can answer a couple questions about that. This is her personal account. What were her expenditures for in that credit card account?
So within this particular credit card account, there were a variety of expenditures. There was items for Disney resorts. There was higher-end clothing, higher-end dining out or meals, if you will, Sephora, Victoria's Secret, et cetera.
And can you read off some of those amounts? I believe that some of those are flagged: Victoria's Secret, Osaka Steakhouse.
Yes, so on March 18th, Osaka Steakhouse, there was $85. There was Sand Dollar Lifestyles for $639. Walt Disney World pass payment for $125, et cetera.
And there's multiple statements there in that exhibit.
Yes, sir.
Is that indicative of her, all the records that you've looked at as far as her purchases?
I believe that's indicative.
Are there any utilities that were spent, or did she use any money for any utilities or home as well?
On this particular credit card or on others?
I think just in general.
There were some charges in relation to personal utility payments, yes, sir.
How can you characterize how much of that was personal or utility related versus the ones that you just mentioned, such as Osaka and shopping and luxury goods?
So if we were to look at just the Chase corporate credit card for Brandon, and if we were to just focus in on utilities, utilities make up in the single digits of the entire population of the transactions that were identified as being unauthorized. If you were to just count online shopping, clothing, that represents approximately 26% of the entire population for those Chase credit card transactions. You have approximately another 27% that relate to higher end purchases such as Disney, Universal, Victoria's Secret, etc.
I'm going to have to object, Judge. I don't know which numbers he's using to base his percentages on, so that would be a violation of the stipulation.
Overruled. I don't think it's violating it.
Again, you would continue. What percentages? I can't remember where you left off now.
Sure. So 26% roughly for the closed and online purchases, 27%-ish for the higher end items. If you were to include utilities, gas items, grocery items, and lump those items together, and those grocery items would be, lumping Walmart and Target together, you would approximate 38%. But within that 38% amount, 43% of those purchases occurred on weekends, such as Saturday or Sunday, when Mrs. Porter was not being paid to work.
And you mentioned that specific that Chase credit card. I'm going to approach, if I may, Judge, with State's Exhibit 4. I think we're on.
Are you?
I think I can
finished with
publish that.
3?
Yes, Judge.
And that's already been admitted? Thank you. You may.
Recognize this document?
Yes, sir, I do.
And what is it?
This is a statement from Chase Bank in relation to the corporate credit card for Brandon.
Fair and accurate, and it has business certification.
Yes, sir.
I'd like to admit State's Exhibit 4 in evidence.
Objection? Without objection, the court will admit State's Exhibit 4.
And this is the firm's credit card bill for one statement, right?
Correct.
Can you kind of convey to the court what those expenses were used for? Or what purchases she made on that?
Sure. Similarly, there's charges for Sam's Club. There's charges for Victoria's Secret, Lucky Brand, Ulta, Osaka Steakhouse, Bells and Whistles, TransUnion, Game Changer Media, etc.
What's the total? Do you know what the total amount for that one statement is?
Total purchases on this one statement. The statement period ending May 4th totaled $11,367 for this one statement.
Is this a sample, or just a small sample of what you reviewed?
Yes, sir.
Is it indicative of the rest of the statements?
It is.
I may publish that now to the judge. Did she manipulate records to hide this?
Yes, sir.
And can you explain how she did that?
She did that in a variety of methods. Mrs. Porter, in her job responsibility, was in charge of maintaining the books and records for Brandon and Brandon, which was, as I mentioned previously, the QuickBooks file. So for several of these transactions, she was not recording those in the books in an effort to apparently to conceal those or from Brandon to Brandon. There was also transactions that were being posted and changed to different vendor names. So a payment to Chase might be changed to a expert witness that the Brandons had utilized in the past. She was also posting several of those transactions to a client advance account. And what that client advance account is essentially a receivable account for something that the Brandon can go back to their clients and essentially recoup that cost. And so if they're focused in on just the profit and loss of the business, income minus expenses, they're essentially those transactions are not being captured. And so during our review period, that client advance account or that receivable account increased by well over $500,000 during our review period. And that was primarily because Mrs. Porter was essentially funneling those transactions instead of posting them as an expense. She was posting them over on this account in an apparent effort to conceal those transactions.
And that takes a conscious effort. That's not something that can be mistakenly done.
Objection, leading.
How,
Rephrase the question. I'll sustain it.
how would that be done? Would someone make a mistake and do that?
No, sir.
Was it consistently done?
Yes, sir. Starting in prior to 2017, it was primarily not recording them on the books. And 2017, as you go further on, it got more sophisticated where she was altering the vendor names in the books, breaking up transactions into multiple different transactions. Instead of a $5,000 amount, there might be 5 or 6 different amounts that total that $5,000 amount. So as time went on, it became more sophisticated.
And you use the term sophisticated. Does it require a lot of sophistication?
In my opinion, yes.
How long did it take you to uncover all this?
A long time.
Hours, months?
Hours.
Did the defendant ever assist with your analysis?
No, sir.
Did she ever, to your knowledge, assist anyone else with your analysis?
Not to my knowledge.
Now, the state stipulated to a loss amount of $307,000. That's clearly attributable to the defendant, that amount, correct?
Yes, sir.
I don't have any further questions.
Any cross, Mr. LaPella? Thank you. You are excused.
They would call Investigator Kruger.
Would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Please be seated. Counsel, you may inquire.
Yes, sir.
You state your name for the record.
Michael Kruger.
And Mr. Kruger, what do you do for a living?
I'm a senior investigator with Okaloosa County Sheriff's Office.
And what kind of training have you received?
I'm a CFE, or Certified Fraud Examiner. I'm a certified fraud investigator through the International Association of Financial Crime Investigators.
And how long have you been, I guess, what kind of tasks are you normally given?
I work, I'm also on the task force for the FBI for white-collar crime. I usually work fraud cases.
How long have you been doing that?
I've been doing that now for
About 6 years, 6.5 years, just white collar.
Are you familiar with this case involving Janice Porter?
Yes, sir.
How are you involved in this case?
I was contacted by patrol and told about the situation, and that's how I got involved and contacted the Brannons.
Did you conduct an investigation?
Yes, sir.
A lot of that, let me put it this way. The accountant, Ben Kincaid, was also involved in this investigation.
Yes, he handled the forensic accounting, reviewing the accounts.
Did you attempt to make contact with the defendant?
Yes, I did.
Okay. Did she speak with you about the case?
No, she did not speak to me directly about the case. She gave me her attorney's card.
Okay. Did the defendant or attorney ever reach out to you to solve this matter?
No, not, we did talk where we had the depositions, but as far as coming to a conclusion, no.
Never assisted you in looking through records?
No.
Never made any other statements about?
Objection leading.
Chief, any cooperation at all given to your?
Not to my
Objection
knowledge.
leading.
Overruled.
Thank you. Further questions?
Mr. LaPella.
Do you know what date you started your investigation?
I know it was at the beginning of COVID. I can't tell you the exact date.
Was it after Ms. Porter came to the sheriff's office in Shalimar and made some statements, or was it before?
No, it was after that. I was contacted by the corporal who said we have a female at headquarters wanting to be arrested for embezzling money from her employer. But she said if we don't arrest her, she would kill herself. So I said it's more important to Baker Act her than it is to look into this until we have a complainant.
You didn't have any basis to arrest her at that point? You didn't have probable cause?
No, sir.
And you couldn't just go based on her statement?
No, we'd have to have a victim first, and also we'd have to have evidence.
And did you have a chance to take a look at the text she sent the Brannons?
I believe I have. It's been since 2020, so it's been a while.
And that text was sent before you started the investigation, right?
I believe so.
And as part of your investigation, you are aware of who James Morgan is?
Yes, I am.
Okay, and is he a real person?
Yes, he is.
And what state is he from?
He's in Georgia, Atlanta, Georgia, to be specific.
And have you applied for a warrant for his arrest?
No, he's on probation right now for doing a similar type of crime in Georgia.
Okay, so there's no further prosecution of Mr. Morgan?
Overruled. You opened it up and asked about this throughout. You may proceed.
Okay, can you rephrase that, sir?
Ask the question.
So there's no pending prosecution of a criminal case for Mr. Morgan that you're aware of?
No, not from me.
Okay, no further questions.
Anything else?
Have you reviewed her statements to law enforcement?
Yes, sir.
Was she honest with the law enforcement officer?
Not completely. She minimized her theft.
Did it harm or assist you in investigating this case?
Well, not being completely honest or straightforward, yes, that slows down the investigation.
No further questions.
I think the scope, I have one further follow-up if I could.
You may.
Would you agree that as part of your investigation in this case, which spanned quite a length of time, you received audits and forensic audits from the Ben Kincaid, and you reviewed that?
Yes, sir.
Okay, so is it fair to say that there was a discrepancy in the amount of restitution or the amount of money that was taken?
It would go back and forth because as they would dig into more records, they would have more accounts that became known. And there was some issues with some ACH transfers that they weren't able to track.
So it was an issue regarding the amount of restitution.
Well, as far as what I did, it was based on everything that I could show directly tied to Miss Porter. And as far as you brought up Morgan, that was a completely separate case for the amount of money that he took.
Was there any evidence that you collected that would have indicated that she audited her theft prior to her leaving the Brandon firm?
I'm sorry, did she what?
That she self-audited her theft, that she went through the computers and counted up how much she'd actually taken over a period of time, that she would have had knowledge of that amount?
I didn't see that, but I did see that she had changed items such as things that Morgan had taken. She'd changed the names.
I asked you if there was any evidence that she counted up what she had taken.
I had no idea if she did or not.
So she wouldn't necessarily, if she went and told the cops, I stole some money, she wouldn't necessarily know the dollar amount.
When you're talking a small amount to
I'm
compare.
sorry, there's no evidence.
Oh.
I'll restate- I'll
Objection,
restate-
approach.
I'll restate the question, Judge.
He's objecting. Come on, come on.
I'll withdraw the question. Thank you, Judge.
Anything further, counsel? Thank you, officer. Appreciate your help.
Thank you, Honor.
Any further witnesses, counsel?
Call Officer Winkler.
Would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Yes, sir. Please be seated. Counsel, you may inquire.
Would you state your name for the record?
Richard Winkler,
And Mr. Winkler, where do you work?
Okaloosa County Sheriff's Office,
And how long have you been there?
15 years.
Are you familiar with the defendant, Janice Porter, in this matter?
Yes, I am.
How are you familiar with her?
She made contact with me at our headquarters.
And what was she doing when she made contact with you?
She said she wanted to be put in jail for embezzlement.
You recall her mentioning specifics of what she alleged to have occurred?
Yeah, she said she'd been taking money for some time. She told me approximately a year.
She told you a year?
About a year, I believe is the way she said it.
You remember her mentioning any amounts?
She said around $5,000 a month.
You recall if she said anything about whether she was concealing this or keeping it from anyone?
She said she had told, I believe, her boss and sent an email to her husband that morning or the day before, but just recently. She said it was coming to light because someone else was taking money too.
Did you later find out if those were true statements?
I did.
And were they?
No.
Did you think that she cooperated with you in solving anything?
No.
No further questions.
Mr. LaPello?
Officer, are you disputing that Ms. Porter came to the sheriff's office and admitted crimes to you?
No, that's not what I'm disputing.
Okay. So she did admit crimes to you.
Yes.
And so she said she had taken money for some time from her employer,
Yes.
and she admitted to concealing it,
Yes.
and she asked to be put in jail.
Yes.
And was there an investigation that had been initiated at that point?
No.
No further questions.
Redirect.
There's a transcript of the interaction that you had with her, right?
Yes, sir.
Did she ever make any statements along the lines of that I told them it had only been happening for 2 months?
I'd have to see the transcript.
Was it a transcript refresh your recollection?
Yeah, I'd have to see a transcript on that. Yep, it's in the transcript, so.
That was a fabrication.
Yes.
Thank you. No other questions.
Anything further? Mr. LaPello?
Sure. Is the state going to submit a transcript? Because I think there was a body-worn camera.
I can. There's a body-worn camera. However, the defense wants to do it, I'm fine with submitting either. That may be easier to talk about some of this than.
I don't,
He refreshed his memory. It was refreshed. I don't think it has to be offered, but if you want to offer it, it's up to you.
Judge, I'll offer it as Exhibit 5.
Okay. Objection?
well, I don't think there's, I think he's established a foundation, but
You can object. I'm asking you, are you
awkward.
objecting to the admission? It's
I
and then
can't
I'll ask you
object- I
why.
can't object to the admission, Your Honor.
Okay, and I'll admit it.
And it's got mine.
Well, not the transcript. I'm going to object to the transcript being entered at best evidence rule if there's a video.
There are videos. I
The
can admit
demeanor of the
videos.
defendant might be relevant.
Are you wanting to admit the,
Judge, I don't.
he's objecting, I'm going to sustain the objection on that. We'll proceed.
Transcript, I'm not objecting to the video.
I mean, apparently we don't have the video, so.
Judge, I think I do have the video.
Okay.
I have all the videos. Includes Winkler's and Gonzalez.
So is that what you're offering?
Submit it. Yes, Judge.
No objection.
Okay. Without objection, the court will admit State's Exhibit 5. Those are the video of Winkler, Gonzalez, and Gonzalez 2.
Judge, at this time, state doesn't have any other witnesses. We reserve the right to recall or call and rebuttal witness, depending on what the defendant may say.
Very good. Are you finished with this witness, Mr. LaPella? Thank you, officer. And is he excused, or does he have to stay around?
I prefer stay around.
Okay.
Don't release anybody.
Thank you. Are you resting at this point?
Yes, Judge.
Mr. LaPella, you wish to?
Well, Judge, could we approach just to discuss logistics of what we have going forward?
Sure. take a 5-minute recess, and then we will, I apologize, I know we're running late, particularly with the court personnel, but I think we're winding things down. Back in just 5 minutes.
First thing in the morning.
That's right, I know I didn't, but I only think I can vote you. It's all right, I think there's. I got one.
Judges are back to the courtroom.
You were employed there, did your duties change over time?
They did.
What were your duties?
When I started out, I was just the bookkeeper. I just came in 2 days a week to take care of any bills that needed to be paid or, reconciling those things, also doing payroll. It morphed over time. I enjoyed doing the law side of things too, so I was given cases. I carried at one time 15 cases, and I also assisted all the other paralegals on their cases that were in litigation. I did a lot of the marketing for the firm. On the weekends and things, if emails would come in, they came into my email account, into Paul's email account, and it was my job to answer those emails. If new clients had reached out over the weekend or on the weeknight, a lot of times I would email Paul and say, how do you want me to handle? And he would, give me directions. But those were part of it. Sometimes on the holidays, or if the office was closed, we would forward our calls either to my phone or to Paul's phone to make sure that we didn't miss any important calls that were coming in.
Were you salary or hourly?
I started out hourly, and then once one of the other girls in the office, I can't remember if she was fired or if she turned in her notice, but once she was not working there any longer, they moved me to a salary position at that point. And I don't remember what it was at that point.
When did you lose your home? And this would have been in the early 2010s or so?
Yeah, my foreclosure started.
It's listed in the PSI. Don, do you know what time frame that was?
I think it was finalized in 2013. It took years, though. I mean, our foreclosure started years before then. I think everybody went through foreclosure, and it took about, 3 or 4 years before it was finally finalized in 2013.
When the foreclosure was finalized, was there still a judgment?
We did have a judgment, yes.
And did you have any financial obligations based on that judgment?
At first, I did not, but then my wages were garnished. I don't remember when they started to be garnished. I was definitely working for the Brannons. It may have been 2014 or 2015, maybe a little later. I don't recall the exact date of when they were, but once they were garnished, that went on for several years while I was working at the Brannons.
Do you know how much your wages were garnished in terms of?
I don't remember.
Can you explain your situation at the day that you left the firm and went to the police station? What was going through your mind, your thought process?
I will try to get through it. I obviously knew what I had done. And I did enjoy working for the Brannons. They were like my family. I mean, I worked there for so long. The other paralegals were like my best friends. And, Paul was kind of closer to us than Dennis. Dennis was, more of an authoritative figure there. It was good when I worked there. I started doing wrong things and just continued to happen. It started out very, very small and kind of snowballed on me. And then whenever this person, James Morgan, I noticed, first of all, it took me a little while to notice that he had done it because I didn't open the bank statements every month. I opened them once every 3 months. So by the time I knew that he was making that mistake, 3 months had gone past. So I made the decisions that I made, and I regret those decisions. I have spent the last 2.5 years trying to figure out how to say I'm sorry to y'all. I never intended for this to happen, and the shame that I feel is overwhelming. Whenever I left the Brannons and went to the police department, I was completely irrational and I was scared. My family knew nothing about what was happening. I didn't know how to go and face them. And I couldn't obviously go back to work. I didn't know where to go. So the police seemed like where I needed to go. I was wrong. So I went to them to talk to them, and I didn't tell them the full truth of everything, but I did turn myself in, and I would have cooperated fully with anything that they needed, but I couldn't go home and face my family. I didn't know how to do that at that time.
So you said you wanted to cooperate, but you couldn't, and was there something that happened after you was, well, let me back up a little bit. You said, what did you tell the officers you had done?
I told them I embezzled money.
Do you remember how much you told them?
I don't remember very much about being there other than I went in and they told me nobody could talk to me, so I waited, and while I was waiting, this fear just kept mounting on me. I had called Ben, my husband Ben, and told him where I was going to be and what I was going to be doing because he didn't know I had done anything. And I remember sitting in front of the police department and I waited, and I just had all these thoughts going through my mind about what I was going to do and how could I get out from underneath what was going on. I didn't know how to do that. So whenever the officer finally came out, he was very kind to me. And he talked to me and he kept telling me, oh, if it's only $60,000, that's not a big deal. I mean, he was, making me feel better. At the same time, I knew what I was there doing. I did send the Brannons a text message, and I meant what I said. I was very sorry for what I did. It was so out of character for me. I don't understand why.
You said the words "get out from underneath." Could you explain what you meant by that? Were you trying to avoid getting in trouble?
No, I was not avoiding getting in trouble. Everything kind of piled up on top of me at one time. I had the Brandons that now knew and the family that now knew. I knew I needed some space and some time to kind of figure me out and figure out how I was going to explain to them and to my family what had happened.
Where did you ask the officers to take you?
My first jail, and they told me no, there was no charges filed. I couldn't just do that. I think while I was there, after I sent that text message to Paul, I think he called the police department to confirm that I was there, because at some point the police officer said that they had called and they had confirmed I was there. And I needed to figure out how to tell my family and what to tell my family. I was so ashamed and embarrassed and humiliated and sorry for everything.
When they didn't put you in jail, what did they do?
They weren't going to put me in jail, which meant I was going to have to go home and fix my family, and I could not do that. So I told them I would kill myself if I had to go home. I knew I wasn't going to kill myself, but I knew I needed to get my thought process right before I sat down with my family. And I needed that space from them, and I knew, I knew if I said if I was going to kill myself, they would Baker Act me, and that would at least put me somewhere for, 48 hours so that I could try to get. I was a mess. I was really, really a mess whenever I went down there.
Do you recall when your family hired an attorney for you?
Yes.
Right. And after hiring an attorney for you, did your attorney advise you on whether or not to talk to the police?
You told me not to. You told me if they came to the house or called me or contacted me in any way to refer them back to your office, which is what I did.
Now, during this time, there was also a civil suit that was filed, do you recall?
That's right. The civil suit was filed before there were any criminal charges filed.
Now, you went to the sheriff's office on around April 1st, 2020.
That's right.
That was more than 2 years ago.
Mm-hmm.
Now, in your opinion, what's prevented us from being able to resolve your case during that 2-year period?
Well, there was COVID, so the courts were backed up. I knew that James Morgan had taken a substantial amount of money from the accounts, and I knew that money needed to be separated from what I had taken. And I don't know, I don't know the ins and outs. I don't know how long it took them to find this individual. I did try to find him with no success, but I don't know what happened with that. And I've cooperated. Everything that you've given me to cooperate with, I've done.
Was there a disagreement about the amount of restitution?
Yes.
The amount taken by you?
Yes. It seems like every time I got paperwork, the amount had changed.
Did it go up or down?
Up.
You said that you were trying to find Mr. Morgan. What were you trying to do?
I don't know. I just, I have to remember I was doing a lot at the firm on top of what I was originally hired to do. And so a lot of my bookkeeping jobs got pushed to the end of the quarter. Like I did payroll during the week and I paid the bills that came into the office, but the actual reviewing the books that got pushed back to where I was doing it at the end of a quarter rather than at the end of a month. And so I didn't know how substantial Mr. Morgan's taking the money from the account had gotten until, I mean, it was too late to do anything about it. I feel like we needed to separate his amount from what I had taken versus what he had taken.
And the funds that were misappropriated by you, were any of them used to support your family or your housing?
Yeah, it started that way. I started paying my Chelco bill, my gas bill, my phone bill, and then there was never anybody that checked that credit card statement, or the bank statements for that matter. They all came to the office. The credit card statement eventually changed to my house, but not because I changed the address, because I sent a rebate card from them to my office, to my house, and it just I never filled out a paperwork to change the address. But it started that way, and then, it snowballed. I crossed a line. I'll admit, I crossed a line.
What would you like to say to the Brannons, if you were going to make a statement, or to your family, who's here today, I understand? What would you like to tell the Brannons, and then also what would you like to tell your family in the court?
Well, to the Brannons, I thank you for the opportunity that you gave me to work for you. I'm sorry that I broke your trust the way that I did. There isn't a day that goes by that I don't pray for the firm to be prosperous and to recover from what I did, and also that one day you'll find it in your hearts to forgive me. To my family, and I'm sorry for the shame that I brought onto y'all, for every one of you. I don't know if I'll ever get over it. I've tried to take things one day at a time. I've tried to shield you guys from this part of my life, the part that I'm not proud of. I hope that I'm able to be in your lives. I hope that I'm able to see my daughter graduate high school, and my son and my other daughter get married and start their families, and grow old with my husband. I don't have enough words to say how sorry I am to both my family and friends and the Brannons. And to my coworkers that worked there, I loved you all so much. I really did. That was a genuine side of me.
Did you take any other funds after the April 1st of 2020?
No, I didn't work there. I've put myself in a situation where that would happen.
You didn't continue to take any funds?
No.
The whole thing stopped?
Yes.
Okay. Since that time frame, have you worked?
I've worked every day since that time frame.
Where do you work?
My mom has a child care center, so I teach preschool there.
And do you make money working there?
I do.
And what's your salary?
$600 a week.
It's not hourly, it's the salary.
It's salary.
Are you willing to pay restitution in the
I am.
$307,000?
I am. I know they don't want it, but I want to pay it back.
How long do you think it would take you to pay it back?
Depends on if it was in a monthly installment or one lump sum.
Does your husband work as well?
He does.
Would he be able to contribute towards your restitution payment?
We would.
No further questions right now.
Cross.
Porter, I'm going to ask you some questions that can be answered with simple yes and no. Do you think you can do that today?
Absolutely.
Yes?
Yeah.
All right. You'd mentioned earlier that your wages were garnished.
Yes.
Are you indicating that's a reason for why you stole?
No. I had financial problems that had started. So, no, it wasn't the reason that I stole the money.
You spent the money at Osaka's, correct?
I did.
At Victoria's Secrets, correct?
Yes.
At Abercrombie & Fitch, correct?
This has all been established. Yes to all.
These are all luxury items. This is not personal expenses.
I mean,
Or, we'll put it this way. It wasn't meant to support your family in that regard, was it?
not as far as electricity and gas, no.
There's trips to Disney World as well, correct?
I did not go to Disney World. I can't, no. I didn't go to Disney World on their dime.
You didn't book trips to Disney,
No.
even though the records say so.
They may say so, but I didn't, if I did, I don't have a memory of it.
And you were paid by the Brandons about $40,000 in salary?
Thereabouts,
They paid you bonuses, correct?
once a year. Sometimes twice if we had a big case. They did like to make sure the whole firm was equal for that.
This wasn't spent on necessities then, correct?
Some of it was.
Some of it was. Is Abercrombie & Fitch a necessity?
Is Chelco a necessity?
Is going to AMC movies, $100, as the bank statement says, is that a necessity in your mind?
No.
You remember giving statements to law enforcement. Do you recall saying that I made a rational decision. Whenever I didn't get caught, I continued to do it, correct?
I don't remember a whole lot from that statement at that time, so I don't know.
The
I have
body-
not read the transcript or seen the video.
Body cam would be the best evidence of that.
I haven't seen it, so I don't know.
You told the law enforcement officers that it's over 100,000. I mean, have taken 5,000 or only taken 6,000 at the time.
Again, I don't remember, I was in such a state of mind, I don't remember very much from that time, and I have not read the transcript nor seen the video of that time.
In actuality, you, over the course of 4 years, stole over $200,000, over $300,000.
I didn't keep a running total of it. I didn't.
You didn't keep
If
a
that's
running,
what the records say,
you
I
didn't
didn't-
keep a running total of it because you're just using it, as you mentioned,
that's right,
without thought or without processing.
that's right.
But you knew it was a rational decision that was being made.
What was a rational decision?
You chose to go and spend thousands of dollars on the credit card from the law firm. Is that correct?
It was an irrational decision, but it's one that I made.
You mentioned that you told the law enforcement officers that you knew you were not going to kill yourself, but you told them that anyway. Is that correct?
I wouldn't have killed myself. I love my family.
We're not honest with the law enforcement officers.
We've already established I was not honest. I was irrational, and I wasn't making my judgment was so off during that time.
And you didn't tell the Brands the full extent of your thefts, correct?
I just knew I needed to stop that James Morgan from getting more money.
You mentioned James Morgan. That was about the time that you did stop, was when basically you couldn't hide it anymore, correct?
Not with the amount of money he was taking out of the account over that last 3 months. I could not.
Because you
no.
couldn't hide your amount of money that you were stealing.
That's correct. Or his.
That's when you turned yourself in, correct?
It was his. His was far more than mine.
We could look at the bank statements on that. Have you reviewed those bank statements?
No, I haven't.
Have you helped the Brandons or law enforcement in any way review those bank statements?
According to my attorney, I wasn't supposed to speak to you all.
You didn't make any conscious decision to do that yourself, though, did you?
My attorney advised me not to speak to y'all.
You worked in a law firm before. You understand that civil suits allow you to subpoena certain records, correct?
Mm-hmm.
There are other reasons to file civil suits, correct?
Of course.
You never paid them back anything either, is that correct?
Not to date.
you lost their trust, correct?
I did lose their trust, unfortunately.
No further questions?
Mr. LaPella, any further questions?
Do you wish that the money, the restitution amount of the money would have been established a long time ago?
Yeah, I would have loved to close this chapter of my life.
When you went to the officers on April 1st, 2020, did you tell them that you didn't steal, it was someone else?
Oh, I told them that I had, but also someone else had.
So you weren't trying to hide your theft? Okay. And you admitted embezzling?
Did.
Were you trying to hide your theft and trying to blame it on James Morgan?
Well, no, I couldn't do that. I mean, clearly I'm responsible for a portion of it.
So you didn't go to the police and say, James Morgan stole this money. You said you stole some money.
Right.
And why haven't you paid the money back yet?
To the Brannons?
Yeah.
Well, we have a civil suit pending, so that's kind of limited the way I can answer certain questions. Also, they've been very adamant they don't want restitution, even though that's one of the only ways I know I can.
Does it have anything to do with the fact that the amount of restitution was in dispute for a long period of time?
And also that, yeah, we just agreed on that not too long ago.
Is there anything else you'd like to inform the court?
Not at this time. I'm so ready to move past this. I'm very sorry.
No further questions.
No questions, Judge.
Thank you, ma'am. You may step down. Any further witnesses, Mr. LaPella?
No, Your Honor.
Although the court intended to make a ruling this afternoon, I'm unable to do so because I have to view the tapes that came into evidence. That was pointed out, and I agree with that, and so I'm going to endeavor to do, and rather than keep you all here till 10 or 11 o'clock tonight, we're going to have to come back. I apologize for that. I'm willing to do it based upon y'all's availability either tomorrow or the next day. So what do you
Tomorrow morning, Judge?
no, got to watch the tapes. It'll be either tomorrow afternoon, 4 o'clock, thereabouts, Friday morning, 10:30 or 11, Friday afternoon, 3 o'clock.
The fence is available anytime.
I'll not be available tomorrow afternoon.
How about Friday morning at 11 o'clock?
A bond hearing, Judge.
Can you get somebody else to cover the bond hearing, counsel?
Judge is dealing with the nebula hold, which is a source of, it's a complex.
Tell me when you're available.
I can do Friday afternoon and cancel.
Friday afternoon at 3 p.m. Is that all right, ladies? Clerk, finish. Okay. Okay, Friday, 3 p.m. Friday, that is November 4th.
Thank you, Judge.
Thank you all, and I thank everybody in the gallery. Y'all were very attentive, and respectful. Thank you.
All rise, please.
Thank you, ladies. Sorry to keep you waiting.